Attorney L. Reed Bloodworth is the founder and CEO of Bloodworth Law, with offices in Orlando, Florida and Winter Haven, Florida. Reed handles trust litigation, probate litigation, business litigation, and employment litigation. In this video, Reed explains affirmative defenses, which are part of the pleading process in a lawsuit. Reed said that the first thing that happens in a lawsuit is that someone files a complaint, or in the context of a will contest, they file a petition. The respondent or defendant then has to respond to that. You can respond to it either with a motion to dismiss, if you believe that the petition or the complaint doesn't set forth the necessary facts and elements to support a claim, Reed said, or you answer the complaint and assert your affirmative defenses to it. The affirmative defenses are the defenses to what the petitioner or plaintiff is claiming you did wrong. An affirmative defense is something where it's not just a denial, it's having a valid legal reason for doing what you did. You file a complaint, and in the complaint, there are causes of action. For example, a breach of contract, Reed said. And you have to plead your elements to the breach of contract. 1. There was a valid and binding contract. One party breached the contract, and as a result of the breach, the plaintiff was damaged. That's similar to when you plead an affirmative defense. An affirmative defense has to be a defense that's recognized by law. You've got to set forth certain elements and supportive facts. You can't just make a legal conclusion of an affirmative defense. Reed said that there are many affirmative defenses when you're dealing with a breach of contract. One affirmative defense to a breach of contract is that you have to actually attach the contract to your complaint. If you fail to do that, then one affirmative defense is the failure to attach document to which you're relying upon for your breach of contract claim. Then you have many other standard affirmative defenses. When you start talking about affirmative defenses, again, that is case and fact specific. There are many types of affirmative defenses to different types of claims. A very standard affirmative defense is failure to state a cause of action. What that means, for example, someone filed a lawsuit for a breach of contract. They allege there was a contract that was breached, but they didn't allege that due to the breach, the plaintiff was actually damaged. Well, because you didn't allege that element, we can assert an affirmative defense that says you did not set forth all of the required elements in your complaint, and therefore it's deficient, and we should prevail. And that can go for any type of cause of action in which the elements aren't pled. There are many, many affirmative defenses, and they all arise out of the facts and the types of claims made in each case. Attorney Reed Bloodworth is founder and CEO of Bloodworth Law. When an argument between parties becomes a legal dispute, it may be time for an attorney to address it. Talk with Reed about how Bloodworth Law can help you, your family, or your business.